Good evening, everybody. I think we're going to get started now. Thank you for coming out to our panel on government regulation of big tech companies. My name is Sage, and I'm going to be the moderator this evening. I am the president of the Rice Federalist Society, which was one of 4 organizations on campus that organized this panel. I'd like to thank the Baker Institute Student Forum, the Rice College Republicans, and the Rice Young Democrats, as well as the rest of the Federalist Society Executive Board for their efforts in getting this organized. So why did we want to cover this particular topic? I would just ask, who here uses a product or service offered by Google, Facebook, Apple, or Amazon? I think if we add in Microsoft and a couple others, I think that would hit just about everybody. And then, how many of y'all would like to work for one of those companies? Oh, I think some of y'all are lying. Personally, I would love to work for those companies, and I mean, I took Comp 140, so I think I'm qualified. So, job offers, I'm expecting them any day. But while these companies have brought a lot of convenience to our lives in our ability to access information and communicate with each other, they've also presented unique challenges, and particularly legal challenges. So take speech, for instance. Now that so much of it takes place through Facebook and Twitter, there's a question of whether their content moderation is necessary to prevent obscenity and coordination of terrorist groups and that sort of thing, or whether it's a new form of political censorship. We also consume a lot of machine-generated speech in the form of custom search results and tailored advertisements, and so there's a question of how that should be regulated. And in order to do that, to have those custom and tailored search results, and advertisements, there's a ton of data being collected about ourselves, which presents a lot of privacy implications, which that can take the form of website cookies, geotagging, health tracking, and now there's also the always-on listening devices like Alexa and Siri, and there's improved facial recognition software, and it seems almost unavoidable that we're going to have our data collected, whether or not we consent to it. So the question is, should the government be doing something about this? And will the government end up taking advantage of all this data somehow? And so today I ask our panelists, what authority does the government have to regulate social media platforms and big tech companies? And is the current law sufficient to protect the interests of speech and privacy? Each panelist will have 10 minutes to give their take, and then we'll give them 3 minutes for conclusions or rebuttals, and then we'll go to audience Q&A. And with that, I will introduce the panels from y'all's left to right. This is Mr. Drew Tedford, who is Committee Director for the Texas Senate Committee on State Affairs. He's formerly the lead counsel for Texas Senator Brian Hughes, where he helped write the Social Media Deceptive Trade Practices Act. He is also a Rice alum from Baker College. Do we have any Baker College people here? Okay. Man, if he was at Jones College, I think we would have got a bigger response.
We're used to that. At least it's not Will Rice. Time out. You gonna censor me?
In the center we have Professor Dan Wallach, who should be a familiar face. He is a professor in the departments of computer science and electrical and computer engineering. His research interests include mobile code, wireless and smartphone security, and security of electronic voting systems. He teaches Comp 215, Introduction to Program Design, which every CS major in here will take or has taken. And then finally at the end is Professor Josh Blackman. He is an associate professor of law at the South Texas College of Law. He specializes in constitutional law, the Supreme Court, and the intersection of law and technology. and he has written about a tort to defend digital identity and whether data is constitutionally protected speech. Thank you so much for speaking here tonight, and with that, we will be starting with Mr. Tedford.
All right. I have a really cool Zuckerberg meme about Facebook jail, but there's no PowerPoint, so you can just imagine it. It was really cool. The question, I'm from East Texas. I work for a state senator named Brian Hughes. Each state senator represents about 900,000 people. He's from the Tyler area. Is there anybody else? There's one Baker guy. Anybody from East Texas in here? That's what I figured. That's fair. Our constituency is probably a little different than the student body at Rice, and so we kind of, we work with the policy that's statewide, but we work specifically to further the interests of our 900,000 constituents in East Texas who are, pretty deep red, kind of deep South style voting bloc. And a lot of them are put in Facebook jail or Twitter jail pretty often, I think. And probably they ought to be more often than not. But the question was whether the government can address speech on social media, I believe specifically. And I think that the rest of the panel is going to talk some about data privacy and some other related issues. But I'm going to talk about the ability to regulate at the state level. There's also kind of a push from Senators Hawley and Cruz at the federal level to maybe take an antitrust approach. That's a tool that we don't really have in our toolbox at the state level, so it's not one that I'm going to concern myself with at all. On the question of whether the government has the power to address freedom of speech issues on social media, I want to start by saying it's our hope, and ideally they won't need to. I think they do need to right now, but the longer that we go without it, hopefully this conversation will progress to the point where there will be less and less need to. I personally think that Facebook's approach to political ads here has been about the best they could probably do. I think it's better than Twitter. So Facebook said, we're not going to decide if something is true or not. We're going to tell you it's a political ad. You're going to know that it's not an objective statement. It's a motivated statement motivated by a political objective, and you can decide accordingly. Twitter just said we're going to stop taking political ads. I think allowing that speech and then just flagging it for us allows us to make that decision and is right. So I think it's a step in the right direction. But if the free market or kind of political pushback can't solve it, then it may fall to either the federal government or the states to regulate it. Tech companies hate state solutions because it creates a patchwork state by state across the country. They have to respond. We're seeing that in California with some data privacy, right to know issues, and the practical outcome of that is that if a big state like California or Texas passes a law that the tech companies are going to have to comply with, then the rest of the country is likely to reap the benefit, or what I would see as the benefit of that law. But I think there's two approaches that are worth discussing, and you can please help keep me honest on my time. The first one is the public square approach. So the idea being, if you go stand on a street corner and talk, the government is not allowed to limit that speech. That social media is now the modern public square. It's where we share ideas, it's where we debate, and that the social media companies, the tech companies, are essentially, the government of that space. And so the First Amendment protections only would apply to governmental speech. There's actually a case out of Texas from Corpus Christi, Southern District of Texas, that said we're not going to apply the First Amendment to these tech companies. That only applies to governmental action. But so Texas has a First Amendment in the state constitution, just to say it reads very similarly to the federal First Amendment. But if you said that online speech, social media is now a public square, there's a Supreme Court case from 1946 that gives us, I think, a fighting chance to make that case. It was Marsh versus Alabama, and the deal was, it was a company town, so it's private property owned by, I believe, a mine, and some Jehovah's Witness folks wanted to go pass out their literature, and the company that owned the company town wouldn't let them come on and pass out their literature because it was private property. But the people who lived on that private property lived there, worked there, shopped there. Everything that they did was there, and so there was really no way to access them with speech other than to go in and do that. And the Supreme Court held that that was essentially a public space, and while the company wasn't a governmental actor, it was fulfilling a governmental role or action, and so they were going to prohibit them from limiting speech in that space. I think it's a reach. I don't think that would work. I don't think it's our best bite at the apple to take that approach, but it is an approach that is worth considering and that I think is relevant to the question. The approach that we took is, I think, has a better chance because it only applies to commercial speech. So we filed a bill last year in the Texas legislature. It's in session January to May for 20 weeks, every odd-numbered year. Senate Bill 2373, it passed the Senate. It did not pass the House, so it's not law. But it took a consumer protection approach. So Texas has the Deceptive Trade Practices Act for the sale or lease of goods or services. If you basically, advertise falsely, and there's a whole list of items that would violate the statute, then you're subject to damages. And so what we did is we said, if a tech company creates a social media space and publicly claims that that space and the venue is viewpoint neutral, then if in practice it's not viewpoint neutral, and we had a list of deplatform and shadow ban and a bunch of terms of art, if they do any of these things, if they block a user, put you in jail, whatever, for your speech because of the content of that speech when they claim to be content neutral, then they're going to be subject to damages. And so we didn't let just anybody sue that company. We said the Attorney General is going to have to bring that on behalf of the state. So there was a little bit of measure to it besides everybody just going and filing lawsuits. So you have any sense of where I'm at on time? I'll try to hustle up.
3.5 minutes.
Okay, so in federal law, there's the Communications Decency Act. It was passed in the 90s at kind of the developmental stage of the internet, and it provides some guardrails for companies on the internet to keep from getting sued for the content that users post. So the idea is, I'm a user, most of you probably know, anybody in here familiar with the CDA, Section 230, okay, couple? The idea is, if you post a video to YouTube, do you post videos to YouTube? No? If you did, and it's problematic for YouTube, then they're not on the hook for that. You are, because you're the one who posted it, and they're only the, it was like from message boards in 1994. And so what it says is states can regulate beyond this as long as it doesn't violate the direct terms of this statute. And that statute says that these companies are allowed to moderate speech for obscenity, extremely violent. Let me read you the list because it's important to this conversation. No provider or user of an interactive computer service may be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. And so what we did is we wrote a statute that said, if you say that you're content neutral and then you're not content neutral, then the Attorney General can sue you. However, that doesn't apply if you are editing or, making editorial decisions about content that meets one of these. So the otherwise objectionable was an issue.
It's a pretty broad hold.
It's a pretty broad hold, but there's another line of cases that says that otherwise objectionable doesn't make it entirely subjective. If I say, you're not allowed to bring lions, tigers, leopards, and other felines into Sewell Hall, then that doesn't necessarily mean that you can't bring your cuddly kitten. It just means that the cheetahs, while not listed specifically, are close enough to that class that you can't bring them in here too. And so we don't know how that otherwise, some federal courts have interpreted it to be a pretty broad subjective term, and we admit that. But I think that the Texas statute made a good faith effort to track that language and still provide the state with some ability to respond if these companies, nobody thinks that the companies have a guy sitting on a computer saying, that looks Republican, it's out, that looks Republican, it's out. It's just kind of baked into the algorithms and to the worldview of a lot of the people who have got the great jobs that you're talking about at these tech companies. That's what the bill aimed to do. That's a short form version of it. I'm going to plug one more bill that did pass, 171-0, and it limited speech. It was governmental limitation of speech, but I think it had narrowly tailored in, and it came up in the mayor's race a couple of weeks ago. Governor signed it, and it prohibits deepfake videos that are intended to sway an election. So it says if you make a deepfake video that is intended to deceive and appears to show a person taking an action that they did not actually take with the intent to harm a candidate or influence the outcome of an election, then it's a Class A misdemeanor. So we were talking about deepfake videos, and we have a definition in there. Mayor Turner, about 3 weeks ago, asked the Harris County DA to investigate Mr. Busby based on a TV ad that he ran showing some texts that Mayor says, I didn't send those texts, that makes it look like I did send those texts. We just passed a bill, you need to prosecute him under that. It's not at all what we intended to do, but it shows how limiting speech even a little bit can get ahead of you real quick if you're not careful. So.
That's about your time. Do you have any concluding thoughts on that?
No, that was good.
Does everyone know what a deepfake is?
Wow, that's impressive.
Okay, so just for anyone who's a bit confused, so computers have gotten really good and now they can take someone's image and it's kind of, you can look online at deepfake and you'll see like they can do it for like the Mona Lisa and for like all sorts of art, but basically they can make them look like you're talking. They can take your image from a video and then make it look like you're doing something else. So that's what a deepfake is. It's very hard to tell apart from like the real video, and it's only going to get better, I'm sure.
I should clarify, it says if you do this within 30 days of an election. If you do it 6 months before an election, then the public can figure out whether this is real or not, provide a chance for a rebuttal. But if it's so close in a timeline to an election that there's not a fair opportunity for the public to evaluate the legitimacy of the video, then we thought that that's not legitimate speech. All right, thanks.
Thank you, Mr. Tedford. I think Professor Wallach will have his 2 minutes now.
All right. So I'm not a law person. I can't really say what the law allows or doesn't allow, but I can say what's feasible. I can say what can the technology do, what can you reasonably expect a company to be able to do or not to do. So you can't imagine that there's a human being looking at every Facebook post or Twitter tweet saying, good, bad. Like, the volume is way too high. Facebook could never reasonably hire that many people to look at every single post. Do you want that job? That's not a fun job. And neither can Twitter, neither can YouTube, nothing. So that means you have to automate. So what's the low-hanging fruit? What's the easy thing? The easy thing is spam. Have you ever noticed how little spam there is on Facebook? Even Twitter? There's like, it's astonishing how good these companies have gotten at saying, wait, I've seen that before. I've seen that a lot before. And spam used to be a huge problem, but now we hardly see it. So we can take things, we can classify them, we can bucketize them and say, yep, that looks like other spam that I've seen before. That's the easy stuff. After that, everything is hard. Like, how can I distinguish somebody going on this is my personal opinion, I think that we should vote for X and not Y. How can I tell if that's legit versus if that's, oh boy, another anti-vaxxer who's been, influenced by the evil people who tell them false things about vaccines, and maybe we want to make a stand and say we're going to try to filter out the anti-vax stuff. And then how do you distinguish between genuine anti-vax people and people ironically trying to make anti-vax humor? I mean, computers are really bad at subtlety and irony and humor, and we just don't know how to do that yet. And so trying to build any kind of automated classifier that would work in any meaningful way, we just don't know how to do it yet. Instead, let's let the users upvote and downvote. We'll let the crowd decide. Sounds like a great idea until the crowd gangs up on you, which is totally a thing that happens. That, people might say, everybody, downvote that video. And so suddenly the company is getting all these signals that are being driven not because it's legitimate people expressing legit opinions, but because we're trying to censor political speech. So the companies that are trying to do social media are between a rock and a hard place. They all know. They're all smart enough to know that they're being manipulated. Whether it's being manipulated by the Russians, being manipulated by political partisans, being manipulated by anti-vax people trying to sell you, God help us, healing crystals, all of this stuff, they all know they're being manipulated. Yet, if you run afoul of some law that says that you're not content neutral because your filter's screwed up, now you're on the hook, and you're hardly making that much money, really. I mean, yeah, Facebook makes money hand over fist, but they make it, that's a very fragile source of income. If Facebook pisses off enough of you, you'll all leave. And once you realize that leaving to go to Instagram is still Facebook, then you'll really leave. And they won't get you back. You laugh, but a lot of people think, I'm quitting Facebook, I'm just going to go to Instagram. It's still Facebook. So the challenge for them is how to hang on to you. And if they start having to pay these huge fines, then they can't afford to hang on to you. Or they have to start doing nastier things like compromising your privacy to make it easier to advertise to you. Classic example I read about just recently, the woman who wrote this description was saying that she was using one of these period tracking apps. This is a thing. And she hadn't entered any data for a while. So the app reached a conclusion that she was pregnant simply because she hadn't been using the app for a couple months. And suddenly she was getting advertised at all over the place. Buy diapers, buy cribs, buy baby stuff. And then she went back to the app and said, I had my period, and it all evaporated. That sounds like a private thing, right? So, did she really give permission for them to, be buying, when you sign up for that app, are you really wanting to give the world permission to advertise to you based on your pregnancy status? I think not. And that leads to, and this is an area where I think regulation is appropriate, necessary, and feasible. If somebody wants to build a pregnancy tracking app, period tracking app, that's great. But how should they disclose what they do with the information? Should it be opt-in versus opt-out? Should there be a way that you can, when you see an ad, you can track back where it came from and why? Should there be some kind of a kill button on an ad that has teeth? These kinds of things are feasible. Why am I seeing this ad? The ones I always see is, I'm surfing Amazon for something, new pair of pants. And then everywhere I go on the web for a week after that, people are advertising the same pair of pants at me over and over again. I know it came from Amazon because that's where I was searching for that pair of pants. I didn't give Amazon permission to do that. I know it happened because I was searching on Amazon. Amazon is the one buying the ad. And there's no make it go away button. And there should be. And that's something where regulation could do something that people would, rather than talking about partisan political speech right on the eve of an election, which is super sensitive, how about classification and tracking for advertisement purposes? That's something where we could do something non-controversial and make the world a better place. And if it means that the business model of the free app to help you track your period doesn't work, then okay, they can charge you $1 and get rid of all the ads and make it a quieter, better place. I don't think we have to have the ad-supported infrastructure that we have today. We could build it in a different way. How am I doing on time?
You've got 3 more minutes if you'd like.
Gosh, I could rant on more topics. So, what's happening in the US versus what's happening in Europe could be the topic of a PhD dissertation. But it's worth giving a brief compare and contrast. So many years ago, Europe rolled out, or in the early 2010s, they rolled out laws about how cookies can work. And so suddenly every stupid newspaper says, warning, we give you a cookie. Yeah, whatever, okay. You all see these things. So that regulation was dumb. They were trying to regulate a mechanism rather than regulating what the mechanism does, who can track whom for what. Then they got smarter. And there's something called the GDPR, the General Data Privacy Regulation?
Privacy Regulation.
GDPR.
Yeah.
And every big company you've ever heard of has an entire team of engineers
Dutch,
work.
yeah.
So GDPR. Every big company has a whole team of people who do nothing but worry about compliance with GDPR because there are significant penalties if you don't. And it sort of wraps together a whole bunch of things that give you, the user, more control over these companies. Is GDPR great? Is it terrible? It's something. It's something that says that, countries can regulate the behavior of tech companies, and tech companies will fall in line. And that's something that I think, some version of that would be appropriate to discuss and debate here in the US. How far should we go? Exactly what should we do? Unclear, but I think it's worth having the discussion. How's that? We can come back and talk more later. But take it away, sir.
Thank you. I am a law professor, and it's a pleasure to be here. Thank you so much to Sage and all the other groups for hosting us. My perspective is from the Constitution, and particularly the First Amendment, which makes me pretty unpopular nowadays. The First Amendment's not very popular. People don't like it. Why? Because it stands in the way of accomplishing some wonderful progressive goals. Many of the laws that impose restrictions on social media companies, I think, run headlong into the freedom of speech. So let's take a step back. Have any of you actually taken a constitutional law class? Okay, I see 2 hands, 3 hands, so I'll give a background. The basic tenet of the First Amendment is that the government cannot stop you from speaking. They cannot impose what's called a prior restraint on speech. You do not need the government's permission to speak. That much is easy. The harder part is deciding what exactly is speech. Is speech limited to words I'm saying now? Does speech include things I write with a quill or perhaps a keyboard? Does speech include singing? Does speech include dancing? Does speech include exotic dancing? Use your imagination, right? What exactly is speech? And the short answer is that the court has been extremely protective of what is and is not speech. For example, violent video games. California passed a law that made it a crime to sell violent video games to minors. We all know video games have ratings on them, but those are discretionary. Those are imposed by industry. In California, it would be a crime to sell it. The Supreme Court, by a 7-2 vote, was not even close, found that law was unconstitutional, that it violated the freedom of speech. Even though there's a lot of good social science data saying that video games are bad for kids, that it messes you up, that it makes you a violent person. True or not, I can't tell you. There are other cases involving regulation of data. Something as mundane as information on who buys what medical products, right? Is this sort of data speech? And the court has said that yes, data can be speech. So how does this affect Google, right? How does this affect Facebook or Twitter? Let's think about this for a few moments. How does a search engine work? We have experts here. People know much more about this than I do. But generally, you go to a website, type in some string of text, magic happens, and Google returns you answers, right? We actually don't know what that magic box is. That code is generally not released to the public. But there's some sort of magic happening that generates a search output that matches what you search for. Okay, let's say that Google, when they're creating their magic algorithm, isn't very fair about it. Let's say that they have some business partners they like, and some business partners they don't like. And let's say when they give you the ideal result, it maybe isn't the perfect result, but it's one that aligns with their corporate interests. You'll never know this, right? So let's say Google prefers company A over company B, and they promote company A in their search results, and they demote company B in their search results. You'll never know about it. And what happens with Google is itself the provider. You can use Google Maps or Bing Maps, right? Which one's Google going to recommend? They'll recommend their own product. What happens if the government says we want to regulate this? We think this is unfair competition, and we want to use the power of the state antitrust laws to say you need to promote fair results. You cannot operate in this fashion. Google's argued in the past that the First Amendment stands as an obstacle. That their search outputs, that when you type in a query and it pops a result out, that output is protected by the First Amendment. It's not that your code is protected by the First Amendment. It's not that maybe your the physical hardware, your computer is protected by the First Amendment, but the output is a matter of judgment, right? The same way in olden days, they've never done this, you call 411, right? How many of you actually called 411? Really? I'm actually shocked that I haven't called in more than a decade.
I don't even think it works anymore.
No, but you would call a number and you say, hey, I'm looking for a florist in Houston, can you help me out, right? And then the person at the end would say, okay, there's one over here, let me give you the phone number and connect you. That's generally how it would work, right? The same way you would call a 411 operator who would sort of use sort of discretion to guide you, that's speech, at least protected in some regard. Google says that we are in the same fashion. Now, is there actually a little human being figuring out what the best florist is in Houston? Think like Wreck-It Ralph, right? There's the balls thrown around and trying to direct you on the internet. That's not real. This is all code, and it's all automated. So how can it be, Josh, that this completely autonomous process that has zero human intervention is protected speech? And this is where I think the litigation will ultimately fall, right? When you have these completely autonomous apps or algorithms that have no human intervention, right? I think at that juncture, you begin moving a little bit away further. So let me give you an example, right? Let's start with a simple example, art, right? If I gave you a bucket of paint and canvas that was blank, is that speech? No, it's a blank canvas. But if I'm an artist, which I'm not, and I start combining the paint on the paper and the canvas, I make a painting, right? I think everyone would agree that my painting is protected speech. The government can say, Josh, you cannot paint that. That is criticizing the government. That is an evil idea. Protected. All right, so far so good. Now let me choose a second example. Let's say instead of drawing on a piece of canvas, I use Photoshop. I'm not artistic, but I can use a stylus perhaps. I can draw on a screen and create a beautiful work of art. There are many artists who use Photoshop or Illustrator as their canvas. I think here too that we have protected speech. I'm using a computer, but I'm still drawing. Let me give you a third example. Let's say Photoshop has a feature that is designed for lazy artists like myself. And I just click one button and it randomly generates a drawing. No human input allowed, right? Even there, I think there's some interaction. I'm telling you, I want art, and I'm pressing a button. So the First Amendment applies. Give you a fourth example. Let's say an engineer builds a robot, and this robot can paint totally at random on a canvas by itself. Arbitrary strokes, right? In other words, you turn the robot on, the robot takes a paintbrush, splashes paint all over the canvas. I think that's a harder case because the robot's acting independently. Once the code is compiled and the engineer programmed this random algorithm to swipe the paint, there's less human judgment. And I think this is closer to autonomy in the loose sense. Okay, the AI, I don't want to annoy the computer scientists, but this is autonomy in the loose sense of the word, where there's not much human judgment. Right, now let me think of another example, right? Example number 5. Let's say that you build a robot that create a painting based on a person's preferences. Let's say they know the type of art I like, the type of designs I like, and then based on my preferences, he can create a custom portrait that matches my designs, right? This is sort of what Google does with your search results. They take a general query, and they take knowledge about you, and they combine the two to form something that they think is targeted for your ad. And targeted for likes. This is like the period app, except when you don't have you forgot to update the app image. Right? Let's take one step further, right? An engineer designs a robot that can learn a person's taste in art. The robot knows what you like, it knows what you don't like. And it commissions you a perfect piece of art. I think when you get closer to the spectrum at the end, the argument for First Amendment diminishes. I think the touchstone of where speech and code interact, where they reside, has to do with human judgment. And when you take the human judgment out of the equation, when there's no human interaction, you're getting to the point where it's just a computer making its own slop of paint. And that's an example that perhaps is easy to see. But when we get to sort of Google's source code, it's a lot tougher, right? The search results that they pop out are completely autonomous. There is some human judgment in that you're putting in a query, you're putting in input, and maybe Google's collecting information about you. But I think it's tougher to compare that to my own tweet or my own post on social media. Okay, now let me take a step back. The question Sage asked, I didn't know if it was actually answered, is can Congress, can the government actually regulate these matters? One approach that seems to be gaining some cachet on the right is to treat Twitter and social media companies as if they're public utilities. Right? What's a public utility? If I want to sign up for a electrical service, the government licenses energy to give power. If I'm willing to pay the rate, they're obligated to give me service. They can't deny it. And they have to give everyone in the community the same service. They can't prefer some over others. That's what's called a public utility. The water company operates in that fashion. The power company, for many years, the phone company did. Indeed, AT&T, you know what AT&T was originally the phone company, the Bell system. And yet it's basically a monopoly on phone usage.
Professor Blackman?
Have time?
Yes, you can wrap it up.
Okay, my sentence. So the question is Twitter like the phone company? Or are they merely providing a service that's automatic, just routing phone calls? Or are they actually providing content based on their new judgment? And I think the judgment question is defined how the first one question is resolved here. So we move forward. Thank you.
And with that, we'll let y'all, if y'all would like, y'all can either, you can conclude, talk some more for another 3 minutes, maybe reply to something that another one of the speakers said.
Okay, so I want to chime in about the difference between speech and data, which is, I think, an essential thing. Just because Amazon knows a thing about me, I was shopping for pants, that's a fact. I was shopping for pants. That doesn't mean that that piece of data is a thing that they can now sell to everybody. Because there are plenty of things that are more sensitive in my life than the fact that I needed a pair of pants. And some of those things might be very sensitive. If my colleagues learned about them, it could have a negative impact on my career. If my students learned about things about me, it could impact my ratings. I could get fired from my job if certain things became public. Not that I would tell you, but you can imagine that we all have things in our lives that we don't want the world to know about. And I have a pretty boring life. I'm married, I have a daughter in high school. There's not a whole lot that could come out about me that would be damaging to me. But there are plenty of counterexamples. Friends who you might know, people who are transgender, people who have parents who disagree with their politics, people who, you name it. There's a large example, there are many, many examples of people for whom loss of privacy could lead to loss of, life and limb. And that's not really an exaggeration. And so the challenge is how these companies can both protect speech, yet also protect privacy. And that, I think, is going to be the defining challenge. And this is a place where I think regulation is appropriate.
Any other comments?
So some questions from students.
Okay, to the audience.
From the windows to the wall.
Dylan.
Sorry, we've been talking a lot about the data or the information that these internet companies give us. I think a related question would be the information we give them.
Right.
And so what has government has kind of directed to deal with the profit of that has been the third-party doctrine, which states that we don't have a reasonable expectation of privacy in the data we give to these internet companies. In 2017, that was largely overturned by Harvard v. U.S. by the Supreme Court. I'm curious your opinions of the third-party doctrine, and do you think we should have reasonable expectation of privacy to the data we give to these companies?
I think that's a question for me, isn't it? So someone's paying attention to the Supreme Court. That was a very impressive question. The third-party doctrine is a weird element of privacy law. If I keep information in my house that's considered private, and the government needs a warrant to search it, what if I hand information over to a third party? Well, then it's not public anymore. It's not private anymore, it's public. Okay? Does my bank, which has all my records, can they give the government information with a warrant? Yes. The phone company has a record of all the people I call. Can the government obtain that with a warrant? Yes. What about metadata, right? That when you turn on your phone, right, we all walk around with our phones everywhere. Verizon knows where I am at a given point in time with my location data. Right? They know what data I'm transmitting. They even know what packets I'm sending, what pictures I'm transmitting, what videos I'm transmitting. Can the police ask Verizon for location data without a warrant? And the Carpenter case suggested that they cannot obtain that information because it's such a defining element of who you are and where you exist. So I think there's some drift in the third-party adoption. It's not quite dead yet, but I definitely think it's been weakened with the Carpenter decision. Very good question.
Madison?
Some people recently have criticized sites such as like YouTube specifically for having algorithms that promote or tend to lean towards like alt-right content. Some people feel radicalize people into possibly committing acts of violence more recently. And so I was wondering, I'm not sure exactly this is starting to, but I was wondering where the line is, or where you all feel the line is between the right of free speech of those who are able to upload the content, as Wallach talked about, but then also the rights of companies such as YouTube, should they decide that they want to change their algorithms significantly to like demote that kind of content, or not promote it as strongly as it is promoted now.
So the story goes that YouTube was not engineered to direct people in a particular partisan direction. It was engineered to maximize engagement, which is to say, whatever videos made people watch more, then that's whatever made you stick around the site more means they could advertise to you more. So they were optimizing for this weird thing, engagement, which matters to advertisers, and the fact that that engagement metric drove people into these little vortices of partisanship and strangeness was just an unintended side effect of the algorithm. The algorithm wasn't trying to turn you into a rabid partisan, it just happened that way, oops. And that means that, needless to say, they're now well aware of the problem, and I imagine they're taking all sorts of steps to fix it. Now rather than going purely for engagement, we need to go for what? And now you have this engineering challenge of defining the thing it is you're trying to optimize.
I agree. Wow.
Yeah.
That was such a good answer that I'm very impressed. Wow.
And so I don't know what they're going to end up doing, and the answer is they're going to experiment. They're going to try things out, and they're going to quietly experiment on the public and see where it goes. Because that's how they do everything, believe it or not. And we'll see. It's all about, and they will try to balance harms, balance metrics, and see if they can come up with something that works.
If there are ads ran by, let's say, a digital marketing agency from outside of the US that is contracted by an agency here to be able to run political ads, are you aware of the way that the difference of how it's being perceived if the digital marketing company here is running ads for elections in the nation, and how they look at when they collaborate with or subcontract to an agency, let's say in Canada, for example? What's the difference in regards to how it's looked at online?
How it's looked at by
Specifically, let's say Facebook ads, for example.
How the government views
Regulation, because there's a geo difference, right? So, because of everything that happened before, and bots and so many things in regards to manipulating perception with ads, politically specifically, what's the difference in regards to ads?
I mean, I run into, and this might be for him too, if I run into some political campaign finance and ethics issues, depending on who it's coming from and how it's being routed. But I don't think that it's going to run afoul of any laws as long as it's not affiliated with campaign finance, just for being an international advertisement, essentially.
Yeah, I mean, the international law on the internet gets tricky. Because if you are Google and you're Facebook, you are outputting different search results to different countries, right? If I travel to Canada, or if I travel to the UK, or I travel to China, right? I am not going to see the same search results. The GDPR, which my colleague mentioned a few moments ago, imposes very stringent requirements on certain information. For example, in Germany and other European countries, a person can request a page to be taken down if it violates some sort of privacy regime. They can actually basically cancel stuff on the internet that they find problematic. In the United States, good luck with that, they're not taking a page down. So the answer internationally is very tricky, but I do appreciate the question. Thank you for that.
So it's hard to answer your question exactly, but it's fair to say that the laws governing political speech are a tangled mess because it's speech, so it's protected speech, but there's also the FEC, Federal Election Commission, has detailed rules where the candidates are supposed to report what they spend on their speech, and political speech has to be labeled. You know, my name is Dan Wallach and I approve this message. So the speech is constrained in a variety of ways. But then PACs and super PACs can skirt these laws in certain fashions and can hide where their money came from. So it's a really complicated, nasty area. And what if it's not even couched as a political ad? What if it's couched as somebody yakking on Twitter? It doesn't even look like it's an ad. It looks like just a person agreeing with somebody on a tweet. Where do you even begin to approach that?
So one question I have is for privacy regulations, we have had laws like HIPAA and for healthcare and educational information, right? And there doesn't seem to be like a free speech problem there, right? Like some hospital arguing that, you know, we have a free speech right to distribute people's medical records or something, right? So would it be constitutionally okay to pass a similar law for tech companies that Google, you cannot use people's search queries to do anything other than get a search result back? Like you can't use the information for targeted ads or something.
A very good question. There was a case in 2011 involving the First Amendment and medical data. Medical data laws were found to be speech. This was a Vermont law that restricted the sale of pharmacy records that revealed the practices of individual doctors. So Vermont tried to say you can't sell information about doctors or prescribe no medicines. And the Supreme Court held that was speech. To the extent that you have a person's private information that's restricted, that's a little bit different than we might call public speech that have matters of public concern. But I do think that a lot of our privacy laws that people take for granted do have First Amendment problems. I'm a First Amendment absolutist, which makes me very unpopular on most college campuses. But I do think that most laws are unconstitutional in general. But at least we'll just focus on free speech here. You know, the Congress should stop the first 5 words of the First Amendment. Congress should make no law, period. No, kidding. But I think most laws have some doubts. Even that last one. Almost good.
Maybe I can jump in with a question related to health data. So, Professor Wallach, you mentioned the case of the period tracking app and how they use that data for targeted ads. I know that we have things like Apple Health, and just very recently I read that Google just bought Fitbit.
Yep.
So I'm curious about how these companies are allowed, what are the limits on their ability to use this health data that they require through purchasing this app with all of its health data collected in it.
So technologically, there's nothing that stops Google from merging what it knows about you from your Fitbit account with what it knows about you from your Gmail account. Now, Google has great engineers who care deeply about your privacy, and several of them are very good friends of mine, and I trust them. And as long as they still work there, I don't mind having my stuff in Gmail. But that's personal trust. I trust the engineers to respect my privacy. If I didn't, then I would be hesitant. In fact, several people I've seen are like, wow, how do I cancel my Fitbit account because I don't trust Google? And this is, again, a place where, just like we can have FERPA and HIPAA, can we have some kind of, data privacy for companies? Should I own my data? Should I have a say over what happens to it? That seems reasonable.
I think it's about the relationship between you wearing the Fitbit and the company versus you and your doctor's office. And when you go to your doctor, you have that expectation of privacy that is, enshrined in law, but is also just practically there between you and that person that's standing in front of you talking about your health, versus the relationship between you and the company that owns, the machine you're wearing on your wrist. And if we create that relationship or, make that express, then you could have an expectation of privacy there that you don't.
Thank you.
Alright, I'm just curious to get you guys' take on the recent back and forth between Elizabeth Warren and Mark Zuckerberg regarding the potential use of antitrust law to break up big tech companies like Facebook.
Wow.
I'm gonna pass that one.
Yeah, I figured.
I don't know what exchange you're talking about. She had the really hilarious political ad, control them on there. We're not gonna, fact check stuff. We met with Facebook a few months ago when this bill, had died, and we were talking about how we were gonna move forward. And they were talking about their third-party fact checkers, which is a pretty, sci-fi Lord of the Rings sounding type of thing, that they have groups all over the world who are their, there's some sort of certification or licensure, or I don't know where it's not licensure, third-party fact checkers who decide what is true and what is not true for the rest of us to consume as true or as untrue. That was neat. You were talking about jobs somebody might want, looking to be a third-party fact checker. At a later meeting, I told them how funny I thought the Elizabeth Warren troll was, and none of them even grinned. They just stared at me.
Yeah.
Y'all are now.
So, it's sort of an interest, I am nowhere near being an antitrust expert, but the core question that you're asking with antitrust is, well, let's ignore the legal stuff, that's what our legal expert is for, but would it make the world a better place if we broke Facebook up into some smaller companies? Would we create a better world in whatever dimension you want to define? And that's kind of unclear, because part of the value of Facebook is that everybody's there. And so if you split it up into 10 little Facebooks, they tried this, they split AT&T up into a bunch of little baby Bell companies, and now they've all merged back together again. So it's, what did we accomplish with that? Well, it's kind of an interesting question. Although, would we have the modern world of cell phones if AT&T was still in charge? Probably not. So it's an interesting question of would the world be a better place, and then could we create a regulatory regime to move us in that direction? At this point, you're just as good asking fiction authors as regulators. It's really hard to tell you what would happen to the world.
So, different countries have different laws on speech. And how would the US government react to a company like Facebook taking down an American's post because it violates, let's say, blasphemy laws in Pakistan? What's the sort of legal interaction that would go on there?
The American government has no interest in what Facebook does or does not put up. So if Facebook censors a post because of a blasphemy law in Pakistan, I don't see the U.S. government getting involved in any way. This is a non-trivial concern. Alaska is perhaps an extreme example, but in a lot of countries, Google has to take down search results. If you go to Google.co.uk, the UK version, you will not see the same stuff you'll see here. And they say different versions. My goodness, China, they have search engines that are severely censored, and certain terms simply will not yield results. People have VPN to get around it in various fashions, but in some countries have very stringent limitations on what you see online.
So Twitter actually has a crazy way that it works. When you fetch a Twitter tweet, the API internal gives you a field called withheld in countries, and you get a list of 2-letter country codes where that tweet isn't allowed to be shown. And so when you're in the US, you always get to see all the tweets. And if you're in Turkey, not necessarily. And the cool part is that anybody who lives in Turkey can just change their setting to say, I'm in the US, and then they get everything. So Twitter is not real vigorous about their enforcement of this policy, but it is in there. A more salient example that just came in the news this week, what's the name of the show on Netflix? Hassan Minhaj's Patriot, whatever thing, his political talk show, had a thing on the Saudi alleged murder of Khashoggi, the journalist. Yeah, I've seen heads nodding. Okay, I got that right. Anyway, the Saudis didn't like the piece and demanded Netflix take it down, and it's down. So, that directly, is a punch to the gut. Right? Can they get away with that? Apparently the answer is yes. So, of course, Hassan Minhaj is the kind of guy who will find a way to make fun of Netflix for it and see if he keeps the show. This will be fun.
I think there was recently, the Hong Kong protesters were using either Facebook or Twitter, I can't recall, and then Chinese government had them shut down.
Yeah, they were using a chat app that could do peer-to-peer, so even if the network was down, you could send a message and it would propagate from phone to phone. And I believe the Chinese government ordered Apple to remove that from the App Store. And Apple complied. And, we can argue about whether they should have, but they did.
Let's have one more question from the audience.
I was just wondering if you think a digital services tax in general would address some of the issues surrounding.
Did you say a tax?
Yes, a
It's like
tax.
a monetary tax.
Yes. Do you think that might, and if, for example, if that tax would help, would help reduce the size of tech companies or reduce their activity?
I mean, for every tweet, there's a tax you have to pay?
No, on their revenues, for example.
Oh, just as a punitive measure to
Yeah,
punish
because of computer.
large. Well, one of the better ideas I've heard is to impose a tax on phone calls, right? A penny to kill robocalls, right? And every single tax you have to pay, every time you connect to a call, you pay 1 penny. How many calls do we actually make a month? A couple dozen? It would kill robocalls. I like that idea. But I mean, my goodness, simply putting a wealth tax on Twitter being prosperous, that's almost like breaking them off. I would break up that instead of straight wealth tax. But it's ask Ms. Warren, Professor Warren, but UH, maybe she'll listen to this round.
Actually, can I ask just one more question about, had deepfakes earlier, which is one of those really scary sci-fi type of technologies. So I'm wondering, what right does the regular citizen, the non-celebrity do they have any right not to have their image basically repurposed as a deepfake? Is there any protections?
I think these deepfake laws are very suspect. You're creating art, right? You're creating political advocacy. You're creating things that mislead people to be sure, but you can lie to people. Lying is effective.
Sure, totally comfortable with lying. Totally suspect of third-party truth, deciders. But while Professor Blackman is an absolutist, there's some speech that's out of bounds, that's not protected in the United States. And when we're deciding whether this falls into those categories, I think in general, if you're asking about if they took mine or yours image and did something that was obscene but didn't undermine kind of a fundamental right of the public, then I don't think so yet. I think we might get by with it, depending on the court. We wouldn't get by with it if you were on the bench, but I think that, I mean, there are a lot of states passing laws at the state level. Connecticut arrested a couple of guys a couple of weeks ago for some terrible stuff they said, but they were just walking around a parking lot talking. And Massachusetts has a bill filed right now for the same thing, just outlaw saying certain words. I think that using someone's image in a way that kind of, violates their privacy, assuming that those images, so right now you have to have an image to manipulate the image. Machine learning or AI is gonna, there's several ways they can do it, and you know a lot more about this than I do, but they're gonna look at whatever 10,000 pictures on the internet and then figure out how to make them do what they want them to do. That's a gross oversimplification. You can tell me how that works later. But if you've got pictures of yourself that are available, or people take a picture of you while you're walking around in public, then I don't think there's any protection for that, and I don't know if we can get by with creating protection for that. But I bet you somebody tries pretty soon. Has somebody already tried in a different state, I think?
The German one's one of the first ones I heard of actually being raised.
We're gonna find out in the next 4 or 5 years.
So, if you own your likeness, and if somebody takes you and creates something that you didn't do, then you might be able to assert some sort of a copyright claim.
Yeah, IP is the strongest way of getting out of these things.
College athletes have been very successful at keeping their universities and putting their faces on campus products and selling it, but they're
Actually, that just got changed, didn't it? I could have sworn I just read something about that it's no longer the case.
College athletes, student athletes, sorry, the scare quotes, will not get a cut. They'll be compensated for likenesses.
I think that, yes, just no more.
I was just kind of wondering, quick questions, what is the direction of the person, I guess, in terms of, do you think it's kind of getting more restricted, or is
Well, unfortunately, the First Amendment's not popular nowadays. People like cancel culture, they like, turning people off. Let me tell you something, walking in a street and yelling racial expletives is constitutionally protected. Those Massachusetts, the Connecticut case will be thrown out very quickly, right? There is no hate speech exception in the First Amendment. Deepfakes do not only categorical exception in the First Amendment. The doctrine does not permit these sorts of laws. Almost all these laws have actually challenged and will be struck down. I'm fairly confident about that. I don't think BuzzFeed will be prosecuting the same prosecution that he win very easily.
Yeah, that one I think was just, won't characterize the mayor's efforts.
Yeah, I'll work on that.
But I will say that, let's pretend that I'm in charge of YouTube and I figure out how to automatically detect a deepfake.
Yeah.
And when I see one, I just automatically delete it.
That's fine.
Then, that's a thing that YouTube could do. And that would also that's Google's speech. Google can refuse to accept your speech.
And they were doing that. They made like 3,000 deepfakes, I think, last month, and used those to create a library of deepfakes that you could use to teach machines to identify deepfakes, and then take them and know which ones are real and which ones are not.
Okay, well, with that, we're gonna finish the panel. So I'd like to thank the panelists again for